This is Speaking Freely, and I'm Floyd Abrams. And I'm going to talk with you today about a case that you may remember. Amber Laura Heard versus John C. Depp. Amber and Johnny, once again. And once again, because there is now an appeal that has been filed on behalf of Amber. I'll call them by their first name since we all seem to know them so well now. An appeal by Amber against the judgment in favor of Johnny, or if you'll recall, a $10 million judgment for compensatory damage. Compensatory mean what you've suffered and the worth of what you suffered, and initially $5 million for punitive damages, indicating how strongly the jury felt that Johnny Depp had been mistreated, not just false statements, but that punishment of Amber was justified. So they came in with a $5 million punitive damage, which under Virginia state law was reduced to $350,000. And this is the appeal now of Amber from that judgment. You'll recall she also won a $2 million judgment, but there's no doubt who won this case. Johnny was the winner in front of the jury. Johnny was the winner, I would say, in front of America. But now we're talking about law. We're going to talk about an appeal filed by Amber and filed by new lawyers, very good lawyers who know their way around. Jay Brown is now the lead counsel on this. He wrote, I presume, and signed the appeal brief. And it's a very serious effort on his part on behalf of Amber. And that's what I want to talk to you about. Now, to be clear, I'm not going to be giving you a purely legal analysis. In fact, I haven't sat down and read Virginia cases about this and the like. I just want to give you the reaction of someone who's in the field, who knows the law in this area, and who, like most of you maybe, followed the trial as it went along, just because it was so interesting. What is the appeal about? I want to read you the three statements that are the basis of this lawsuit in the first place. This was an op-ed piece written in the Washington and published in the Washington Post by Amber, and this is the basis of this libel suit by Johnny. 1. Headline: Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And 3, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Those were the lines, and effectively the only lines, in the op-ed piece written by her, which led to and are the basis of the libel suit, of the 10 million plus judgment and the like. So what is the appeal about? Obviously, the jury believed Johnny and not Amber. What is the appeal about? There are first two arguments made that are interesting from a legal point of view, but which I'm not going to spend a whole lot of time on. The first is, what's this case doing in Virginia in the first place? After all, the events, for the most part, occurred in Los Angeles. The witnesses are all in California, and Amber's lawyers are saying it wasn't fair and it violated the law to have this case in Virginia in the first place when it didn't have much of a connection with what the case was about. Now, of course, Virginia is very close to the Washington Post, which is where the statement was made, again, in an op-ed piece in the Post. And my reaction, and a lot of what I'm going to say to you today is reactions, is that a Virginia appeals court is not likely to say that Virginia has so little to do with this, even though there was proper service of process, the case began properly and the like. I don't think it's likely that a Virginia court is going to say, we're going to throw this verdict out wholesale, throw it out, because this case never should have been in Virginia in the first place. The other, what I'll call preliminary argument, which I find in a way even more interesting, is this. It goes something like, we've already heard this case before. Why do we need a second trial? What was the first trial? There was a trial in England. There was a trial in England in a libel suit brought against an English newspaper by Johnny Depp. And in that case, the English court could not have been clearer in basically saying that it didn't believe Amber. The English judge sat, listened to her, listened to Johnny, and said in so many words, I'm not persuaded these things happened that she said happened. And so the English judge ruled against, in that case, against Johnny because he found Johnny not credible as a witness. Now, in this case, the Virginia case, the case I'm here to talk about, started a lot of people, and I was one of them, wondered, is this really in Johnny's interest? He already lost the case in England before a judge who heard her and heard him and believed her. But the case did proceed in Virginia, and the jury, quite obviously, did not believe her. The jury believed him. And so one argument that's made is you don't have to have two trials. We had a trial already. And the English verdict, the verdict which was, so to speak, for Amber and against Johnny, is the one that ought to govern. But the problem with that is that it was a really different sort of case. It was a libel case. Johnny was suing an English newspaper which had carried her charges against him. And in that context, no jury there. In that context, the English judge basically heard them both and basically didn't believe Johnny and said so. And so the argument's made, why do we need another trial? Or why should we allow another trial to have occurred involving the same two people? And it's an interesting argument. My reaction is that it'll be a hard sell to a Virginia appellate court to say that when all is said and done, it's bound by an English judgment in a different sort of case, a libel case, not the case that was tried in Virginia, under different legal standards. In England, the legal standards are quite different than in the U.S. by a judge, not a jury. So I think that'll be a tough sell. It's an interesting argument. There are cases in which foreign judgments are enforced in the U.S., but whether an American court is going to say that with respect to a quintessential intra-American debate, that it's bound by what an English judge said, found, concluded, and applied English law to, which is quite different than American law. Again, I think that's going to be not an easy sale to a Virginia appellate court. What are the arguments that I think are stronger? And I do think that this appeals brief has some pretty strong arguments. The first thing they say is everything in what Amber said is protected opinion. We do protect in the U.S. Because of the First Amendment expressions of opinion. In fact, the courts say there's no such thing as a false opinion. Someone is allowed to express opinion without being hauled into court and the like. And so their argument is this. What she said was a sort of, this is the way I felt about it. I felt this way. I felt that way. I felt institutions protect men. That's what I was writing about. I felt the cultural wrath of the country against me. And so they say that this is really a statement of opinion in that Washington Post article with those three different areas that I mentioned to you. And it's an interesting argument. My reaction, for what it's worth, is that there's even a better argument, a stronger argument, and it's a real one. I think this is going to be a close call for an appellate court. And the reason I think it's going to be a close call is that this is an article she wrote which never mentioned Johnny Depp's name and which never mentioned their prior relationship. And what the article focused on is how women are treated by our society. And so when the question is asked, well, what's the harm here, or what's the basis for the lawsuit in the first place, if that's correct? I mean, remember what the three statements were that I mentioned to you earlier. Quote, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change. Is that an attack on Johnny? Or the answer, of course, is she did it about him. Her charges, the statements she made were about him, not just our culture generally. And then again, the second line was, 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And what her lawyer is saying is, in that language, she wasn't saying, this is what he did to me. In that language, she was saying, This is what happened to me because I spoke out. Now you can figure the answer, right? What is the answer going to be? The answer is going to be, yeah, but what did you say? You spoke out, not abstractly. You spoke out in the context of what you said Johnny had done to you. So the legal and the sort of practical, the sort of logical answer against her is this was not a simple essay in general about how women are treated in America. Everybody who read the article understood that she was what? Implying, sort of saying, presupposing that you understand that what had happened to her, that according to her, had really happened. That's an interesting issue. It's an interesting legal issue because the article never said, it didn't. He did this to me. He did this to me. He did this. And now he denies it. The article is, again, those 3 lines. I won't read to you again. And so it raises a really interesting legal issue about whether there can be liability imposed in a case in which, at worst, there was a strong inference that, of course, what she was talking about is that this person you read about in the newspaper, did something wrong, very wrong, according to her. But that said, it is the case. She didn't mention him. She didn't talk about what it is that she claims he did to her. It is phrased very abstractly. And therefore, there is at least an argument, an interesting argument, an argument for judges to ponder about whether this is a case in which he has a good claim or had a good claim that everybody would understand and did. That what she was saying was that he beat her up, he did this, he did that, even though she didn't mention any of it in the article. You may remember that in this case, because it's tried in America, because it's tried under our law, the judge instructed the jury that in order to find for him, the issue would come up as to the state of mind of her. She's the author of the piece, and the question, one key issue, is whether there was actual malice in what she said. Actual malice is a terrible choice of words by the U.S. Supreme Court in one of its first great cases about libel. And what actual malice means is not malice in the sense of you hating me or I wanting to get someone. Actual malice means saying something with a high degree of awareness of probable falsity. And so one of the issues on appeal will be, was there enough proof of actual malice for him to recover from her? My own reaction to that is that this is a situation in which judges would tend to let a jury verdict stand. It's up to them to decide as long as there's enough evidence. And there was evidence on both sides. There was evidence. She said X happened. He said X didn't happen. That's the sort of thing juries always decide. But the actual malice issue will still be before the court. So, what's the strongest argument when you think back on what I've said so far? What is the strongest argument excuse me, made on this appeal? I think the best argument is the one which starts out reading again, as I did to you, those three statements, statements which didn't mention him by name, and in fact didn't at all flesh out what it is he supposedly did wrong. I mean, these statements were not about Australia and not about wild, drug-filled, alcohol-filled rages. Those statements didn't say that. And so the core question, I think, on appeal is going to be whether reading the article, it carried with it so obviously the unspoken proposition, this is what he did. He did these things, to which the jury obviously decided he didn't, or she hadn't proved that he did. At the end of the day, the jury didn't believe her, and the jury did believe him. And that's going to obviously have a lot of weight with the court. I'm not going to predict how it's going to come out, but I will say that it is not a slam dunk by any means for Amber in the case. Johnny's lawyers have done as good a job as they could. I still think the odds are against him prevailing, but he's got a shot. I should say the odds are against her prevailing, but there is a shot, and this is a serious brief making serious arguments, which the Virginia courts, I think, will think long and hard about. And yet, at the end of the day, it's hard not to suppose, at least, or predict, at least, that more likely than not, this verdict will stand as it is. Let's see what happens. Thank you very much.